Okay, on. Hello, ladies and gentlemen. Good afternoon. Thank you for being here during Alumni Weekend for our afternoon CLE entitled Poor Question Mark, Go Directly to Jail, Evaluation of Bail Reform Efforts. For those of you who do not know me, my name is James Pash, class of 2010, our law school's current Assistant Dean of Development and Alumni Relations. And in the evening, I'm the Vice President of Beechwood City Council and the head of our legal committee. It is my pleasure this afternoon to introduce my colleague here at the law school, Professor Carmen Naso, who was admitted to practice in Ohio in November of 1978. He began his career as a prosecutor in the Cuyahoga County Prosecutor's Office for John T. Corrigan and was named to the first major trial unit prosecuting serious crimes and capital murder. He spent 25 years in private practice as a trial attorney in both civil and criminal matters. In 2001, he returned to the County Prosecutor's Office under Bill Mason and was named Chief Prosecuting Attorney of the Juvenile Justice Unit. He arrived at Case Western Reserve University in 2008 as a supervising attorney in the Kramer Law Clinic Criminal Justice Clinic, where he now teaches. He represented recently and obtained an exoneration for one of the East Cleveland 3 defendants who spent 20 years in prison for a crime that they did not commit. He teaches juvenile law and wrongful convictions currently, and as far as today's topic is concerned, he was named to the Bail Reform Task Force and was one of the 4 authors of the Cuyahoga County Bail Reform Task Force report and recommendations. It is my privilege to introduce Professor Carmen Naso. Thank you.
Thanks, James. That was wonderful, if I do say so myself. Before I start, I know Dan Clancy doesn't like attention, but when I got here, I came on a 1-year contract. I had this cushy government job, and there was an opening for 1 year here at Case Western Reserve, and I applied for it, and I got it. And I remember about halfway through, I said, what the hell did you do? You left this job and for this insecure position at Case Western Reserve. And Mr. Clancy was kind enough. I worked with his daughter at the prosecutor's office, so I didn't feel any hesitation to reach out to you. And you sat and had coffee with me, and you and I discussed how I could be of value to the law school, and you told me a little bit about the politics of the law school, and here we are 10 years later. I'm still employed here, and I owe you a great debt of gratitude, so thanks very much. You know, I'm honored to be speaking here. Alumni Weekend is a very big event for all of us. Last night's dinner was fantastic, and it's just my privilege to be able to address you. And I like the fact that this is kind of an intimate crowd, so we don't have to wait till the very end if there's any questions. I also like the fact that most of us have operated in a system, whether as defense lawyers or office mates to defense lawyers or prosecutors or victims or witnesses in the criminal justice system, and we have an idea of what traditional ideas of criminal justice are. One of the things I'm very proud of is that Case Western Reserve University had its fingerprints all over this bail reform or bail improvement initiative. And I am hoping, as my colleagues I'm sure are, I am hoping that what we do turns the system upside down. And what I'd like to spend some time talking about is the current state of criminal justice and how we got into this issue in the first place, and then spend the second half, if I can, talking about what ideas we had or what recommendations we had. This all started in January 2007 when a young reporter from the Northeast Ohio media group, aka Cleveland.com, aka the Cleveland Plain Dealer, wrote a series of articles called Justice for All. I don't know if you've read them, but there were a series of articles talking about the workings of the courts in Cuyahoga County. In response to that, the Chief Administrative Judge, John Russo, called together a group of about 100 lawyers, judges, administrators down to the Justice Center and wanted to create a committee to look into what this reporter was alleging and report back to him. And so he created a big committee, and I want to tell you that our two deans, Jessica Berg and Michael Sharp, along with Case Western Reserve grad Dean Lee Fisher of Cleveland Marshall, were named to the steering committee. And it was under their direction that we divided into 4 groups. And among the 4 groups, I had the privilege of being a co-chair of a subcommittee, and another subcommittee was co-chaired by our professor Michael Benza, a third by our professor Lou Katz, and a fourth by 1981 grad Mary Jane Trapp, who I had never met prior to this bail reform initiative. I don't live in the 11th district, so I can't vote for Mary Jane Trapp, but she's running for the Court of Appeals, where she was once before. If I was going to start a justice system, she would be a high draft choice. And I know that if she is elected, she's going to represent Case Western Reserve very well. The original inquiry concerned the number of low-level, nonviolent felons sitting in jail in lieu of bond. So these are people who are in jail for low-level, nonviolent offenses, 4th or 5th degree felonies, who are going to be guaranteed probation because there's been changes to our revised code that now almost mandates probation for these low-level people. And the idea was they were going to find a number of people who were going to get probation anyway, but were sitting in jail because they couldn't pay money bond. And then they, between the lines, there was, and who's paying for all of this, all these days in jail? And the problem was there weren't any. And even though the young reporter solicited people such as myself asking, well, do you have any clients who are sitting in jail? And I said, no, and there really were no examples of that. But the important part is this inquiry she made caused us to discover what on its surface seemed like a small problem, but in reality, the scope of this problem proved to produce more injustice for more people in more ways than ever could have been imagined. And this is how it pertains to people who are accused in our municipal courts. But before I really get much further into this, and I said we're an intimate group, and I hope if there's questions we can just address them as they come up. I'm kind of consumed by this stuff, and I think everybody must know about it. And I've been told that that's not exactly the case. And so if I could ask, would somebody, what's all this fuss about bail reform? What's your impression of it? Would you like to, anybody know what the problem is or have some perception? Yes, Ms. Leatherberry.
It's just so unfair to people who don't have access to money.
Okay.
And many of those people are just poor. Many of them, as Cuyahoga County, are black.
Mm-hmm.
So what it turns out to be is a discriminatory process against poor black people.
Okay, and that certainly was what we found, though I will tell you, race had nothing to do with our investigation, though that's a subject for another day. I'm sure that there will be that type of analysis at some point, but it was so tempting because if you just look at the populations, you see that we obviously have a big racial issue or overlay. Yes?
Carmen, what we would see in municipal court, defendants come in, and the judge wants to election or whatever, he set these high bonds like $5,000 shooting for small matters, buying them over. All of you go down the bond commission, down there, and say, okay, $5,000. Same person, goes to the same position, goes to the court, goes to the same bond. And I think this is one of the problems that we're talking about. And I remember this when I was in something they were cool with the old days, and we had a big bonds that were, all you got to here and one this, and this, and that. That's the biggest problem.
Indeed.
You say, yeah, people that
Right. Okay, let's take just one or two more, and then we'll dive into this. Yes?
Sir, I sit on a board of the Adams Board here in Cuyahoga County,
Mm-hmm.
and we fund the common police court with a grant of multi-million dollars for coordinator program. And usually these are fourth and fifth degree felonies that are diverted into areas. Would that affect anything that we're talking?
Absolutely, and we'll talk about that when we get to the cures for the illness. And yes, one more? Go ahead.
There seems to be among judges a fear that anybody they let out who is then picked up committing another crime is going to be down on them and it's going to come up in the next election. So there's an incentive for the judges to make sure these people are off the street.
Mm-hmm. And they don't want to be chased down the street by Channel 19 when that drunk driver that they let go kills somebody. Right.
Somebody a week later.
We're all thinking alike. When we got the steering committee together and we started reviewing the facts of our system, all of these, judicial inconsistency, politicking, poverty, how this all impacts things. So I'm going to ask you some questions. Nobody raise your hands. These are rhetorical. Don't answer these questions. How many of you have ever been arrested? How many of you have ever missed a court date or had a warrant issued for your arrest? How many of you have had your driver's license suspended? How many of you have spent one day in jail on a different level? How many of you have moved more than twice in 1 year? How many of you have changed jobs more than twice in a year? How many of you have had your cell phone minutes run out at the end of the month? These are types and circumstances that are associated with the people who end up in the Cleveland Municipal Court. Now, many of us might have said yes to some of those, but what we did was we showed up at the next court date because we probably had a lawyer. We paid what we had to pay. We served our probation. We got our licenses reinstated, and we're moving on with our lives. It was very simple, but many people, and I teach in the Kramer Law Clinic Center Criminal Justice System and have one of my favorite grads, Zen Kennedy, right there, who will testify that our clients are all poor. They're all indigent people, and we can't relate to the things I just said. We don't know how this impacts those people. So no truer, whoa, I'm sorry, this is supposed to have gone back there. No truer words were ever misspoken, I guess, than what Justice Rehnquist said. And I want to talk historically just for a moment, if I can. Historically, the constitutional right to bail was not some reaction to unfair practices by the British monarchy. In fact, the prohibition against excessive bail and the right to bail was in the English Bill of Rights, which was enacted 100 years before, and it seemed like a great idea to the 13 colonies, and so they adopted that. There's not much legislation regarding bail. Does anyone, criminal defense lawyers here, back in the mid-'80s, the war on drugs? Okay, preventive detention came into existence due to legislation, and this case here is, or this quote, is a response where the Supreme Court said, yeah, preventive detention is okay, but you have to do A, B, and C. So there's not a lot of jurisprudence surrounding the bail issue. The states are pretty much left to their own. So there's not much going on in Ohio until the late 1990s. In fact, in the Criminal Rule 46 is the rule of procedure that governs this, and in just prior to 1998, the rule read, it was titled Purpose of and Right to Bail. And very briefly, the purpose of bail is to ensure the defendant appears at all stages of the criminal proceedings. All persons are entitled to bail except in capital cases where the proof is evident or the presumption is great. And the text of the rule created a presumption for unsecured bonds and personal bonds for petty and serious offenses. So there was a default that if someone was arrested and charged with a misdemeanor or a felony, and there was a subsection that directly addressed misdemeanors that specified personal recognizance or unsecured bonds, that's how they were to be treated by the courts. And in 1997, the people of Ohio created an amendment to the Constitution of Ohio in Article 1, Section 9. And the amendment reads as follows: where a person is charged with any offense for which the person may be incarcerated, the court may determine at any time the type, amount, and conditions of bail. And so that was the amendment. It's kind of a cautionary tale because we have an amendment coming up this next election. We had an amendment last election. It was called Marcy's Law. And it's kind of a cautionary tale as to what we're stuck with when we amend the Constitution rather than let the legislature do what they're supposed to do. But they reorganized Rule 46, and it allowed a judge to determine the type and conditions of bail anytime that jail was a possibility. And so what we see is the incarceration rates skyrocket. From 1983 or 4, I can't remember when, the preventive detention in federal court, and now from 1998 up until today, we are seeing incarceration rates skyrocket. And I found this stunning. 60% nationally, 60% of the people who are incarcerated in our jails have not been convicted of anything, and they're awaiting either their trial or on a probation hearing. They're waiting the ultimate disposition. Ohio does a little bit better. There's 57% of the people in our jails are awaiting their trial. That's not what jails were made for. As many of you know, Cuyahoga County is made up of more than 50 municipal jurisdictions, villages, townships. There's more than 70 different arresting agencies. University Circle Police is one. Cleveland State has their own police department. Cleveland Clinic. And so these jurisdictions, these police departments, when they arrest someone and charge them, those people are filtered into any one of 13 different municipal court districts that we have in Cuyahoga County, the largest being Cleveland, of course. Within 5 miles of where I am right now, we have East Cleveland Court, Cleveland Heights Court, South Euclid Court, Lyndhurst Court. Euclid's pretty close to that 5 mile, and Cleveland fits in that. So in this congested area, we've got, and Shaker, okay, I didn't think of Shaker, but I'm going to think of Shaker in just a matter of seconds here, because this is the first part of the problem that we saw. With all those different municipal court jurisdictions, the reality of our jurisprudence is like judicial roulette, okay? And what you get is justice by jurisdiction. Again, the thing that is so upsetting about this is we're talking about misdemeanor offenses. Even though the look was at felony offenses, which has its own animal. There's a bond commissioner in common police court that reviews these things. I'll get to that in a moment. But we're talking about misdemeanors. Misdemeanors outnumber felony convictions probably 5-6 to 1. There's a hell of a lot more traffic tickets written than there are cases that are indicted, and a heck of a lot more traffic offenses, all of which are misdemeanor offenses. You can go to jail for almost anything outside of the traffic ticket. So what we had is justice by jurisdiction. And I want to give you an example of it, because this is for first-degree misdemeanors. And a first-degree misdemeanor is punishable by a fine of up to $1,000 or up to 180 days in jail. Each individual municipality has set a bond schedule. And that's a good thing to have a bond schedule, because if you get arrested at 11 o'clock on a Friday night, you don't want to have to wait till Monday to see a judge and get out. And so every municipality has a bond schedule, and it is indiscriminate, which oftentimes is a good thing in law, but the bond decision is supposed to be individualized, and therein lies the first problem. So some judge created a bond schedule. And so if you were operating your motor vehicle, I'm going to use the OVI, operating a vehicle while impaired, as an example, but other misdemeanors are domestic violence, theft, misdemeanors of the first degree. But let's say you're operating your vehicle on Cedar, and it's up by John Carroll, where the south side of the street is University Heights. The north side of the street, as you come past Warrensville, is Cleveland Heights. or if you go further, you can get South Euclid on one half of the street. If you are picked up for operating a vehicle while impaired in Cleveland Heights, the bond schedule says your bond should be $2,500. And what you will do is you'll post 10% of that, so that's $250. If you're caught on the other side of the street in University Heights is funneled into the Shaker Municipal Court, and the bond set is $10,000. And so what you have to do is come up with $1,000, depending upon which side of the street you got busted on. I think I want to just step back for a moment. Bail is a process, okay? Bail is not money. Bond is a financial obligation. It's much more like money. The three traditional types of bail, and this is where we mix up bails and bonds, are personal bond, personal recognizance, you don't post any money. Unsecured bond, the judge says, okay, your bond's $5,000, but you don't have to pay anything. However, if you don't show up at court, then you're going to have to post that bond. So that's an unsecured bond. And then the other type, many of us are familiar about this because we watch Dog the Bounty Hunter on cable TV, is a secured bond, and that's what these are. These are bonds that are secured. You have to have a financial outlay. Now, sometimes judges say, whoa, I'm going to make you get a surety bond. And a surety bond is when you have to hire a bondsman. The good news about a secured bond under any of these circumstances is you pay $250 to Cleveland Heights to get out, and Cleveland Heights will give you 90% of your deposit back, in theory. They'll give you 90% of your deposit back. So they'll keep the 10% as an administrative fee so that people don't lose all their bond money, which is what happens when you hire a surety. You have to pay a bail bondsman. The money you give him up front, you never see again. So those are the types of bail. And in all of our municipal courts, as you can see, depending upon what jurisdiction you get into, these are thoughtless decisions. They're just decisions posted on a board, and they'll let you out. They have nothing to do with your own personal circumstances or the individualized assessment that is supposed to be required constitutionally and certainly statutorily. I want to go to a second for the to address the common pleas bonds, and this is when you are charged with a felony. Everybody charged with a felony has to get charged, in very few exceptions, or with very few exceptions, in the municipal court in which the crime occurred. So they'll go in front of a judge in Shaker perhaps, or Euclid perhaps, and it'll be a robbery case, and the judge will say $10,000. And eventually those people will get bound over to the Court of Common Pleas, but at least the Court of Common Pleas has a structure in place where there are going to be numerous reviews to attempt to individualize the person's bond. This might have something to do with the fact that the county jail where they will hold these people is like overbooked by 50% and people are dying in it for no apparent reason. So, but that's a recent thing. These factors and these considerations have been longstanding for just the reason they should. You're supposed to make an individual determination, and it's the nature of the crime, the criminal history, their financial situation, whether they have a job, substance abuse, whether or not, and we'll get to this in a minute, the relationship with the victim, because that becomes pretty important in some of our recommendations. But at least in common pleas court, there's factors that they consider. And in common pleas court, you get a lawyer. Okay, you don't get a lawyer in municipal court at that first appearance. And so, since most of the people who appear in our system of justice appear in municipal court, and most of those people are poor, they have substance abuse issues, there's mental illness, and no lawyer involved. And so what happens is a judge will make someone post a bond, and they can't make the bond. And so they sit around in jail. And this is where things get a little crazy, because on day one, their car gets towed. And, you know, I heard something yesterday. They were interviewing a lady who, she said, I don't have a car. If I had a car, I'd have a job. But if I had a job, I'd have a car. And so people have their car towed. Imagine that. They're working $8, $10 an hour jobs. There's a lot of people to replace them. They miss work 2 days. They're fired. They lose their job. If it's at the end of the month, their rent doesn't get paid. They get evicted. If they're a caregiver and the other person who's helping with the children, all of a sudden the children's lives are disrupted. These are horrific social costs that start occurring about day 2 when you're stuck in jail. And no, I don't know if anyone's spent 1 day in jail. It's nothing I'd want to do. But 2 or 3 or 4 days in jail, you can just imagine how things are mounting up. And I have some eye-popping statistics I'll get into in just a moment. The ACLU is very big on this particular issue. The social costs, the social injustice. I get it. But I'm a lawyer. I'm a criminal defense attorney by day. I'm a person who spends more time defending people. I prosecuted them twice in 2 different parts of my career. But I know, and I know from our clients, that the bigger injustice, at least to me, I get it. Okay, your car got towed. Maybe you shouldn't have broken into that house or done whatever. I somehow in my mind can rationalize these consequences, but what I can't rationalize, and the thing that drives me crazy, is the legal outcomes that get impacted. This is so unfair. What happens to somebody who gets put in jail for even a day or 2 days? Let's assume they do have enough money, or they have a lawyer in their family, or for some reason a lawyer is interested in taking their case. I don't know if any of you have visited anybody in the Cuyahoga County Jail. It's much easier to get in there committing a crime than it is to go visit your client there. It takes at least half of a day. Lawyers don't have a half of a day for a misdemeanor offense. You have to talk to your client through this disgusting screen, holding a phone that you really don't want to touch, with 5 or 6 different lawyers doing the exact same thing right next to you. There's absolutely no privacy whatsoever. So your access to the lawyer is obstructed. Then what about the lawyer's ability to investigate your cases? And I use the idea of white guy in a suit going in to look for witnesses in some areas. That doesn't work. It doesn't work at all because you look like a cop and nobody wants to come out and talk to you. Not having your client to be able to help you investigate the case, that's a terrible disadvantage you're put into. Then efforts to mitigate. I can only tell you anecdotally. The system does get it wrong. By the way, I do wrongful conviction work too, so you better believe the system gets it wrong. But for the most part, the rates of wrongful conviction are very tiny. The numbers are pretty high. But for the most part, the system gets it right. They don't pull people's names out of hats. And so there's a very realistic likelihood that your client is going to enter a plea to something in that case. And it's so much easier for you to go to the prosecutor with your client out on bond, working, making money, so that he can pay restitution for the window he broke or whatever damage that he did. Or for your client who's got anger management issues and was charged with domestic violence at home, or charged with a substance abuse issue. It's so much easier when they can show that they've gone to AA meetings or they've gone to anger management. You don't need insurance for either of those things. Poor people have access to both of those things that will mitigate to the prosecutor so that they're much more likely to entertain a better plea deal. But certainly to the judge, when it comes time to sentence somebody and you can show that these people have paid their restitution or they're getting a handle on the problem in the first place, the outcomes are just so much different. And then what about when you see your client after day 4 or day 5? They'll plead to anything. All they want to do is get out of there. And prosecutors know this. And I'm pro-prosecutor. I'm not saying they take advantage of it, but prosecutors know this. And as a consequence, that increases the leverage that they don't need increased in these pleas. And sometimes people plead to things they didn't do. They might have done something near there, and we can negotiate a plea that somehow represents the situation, but a lot of times they plead to things they didn't do. And in Ohio, which is a very, very conservative state, the collateral consequences, which used to be none back when I was younger, you'd plead to a misdemeanor, it would be like being innocent. But now, you plead to a misdemeanor, and depending upon what misdemeanor that is, you are going to have prohibitions to get certain kind of licenses, to get employed in certain kind of jobs. The list goes on and on and on. And all this poor guy or lady wants to do is get out of jail and get back to his life. That's just a terrible thing. And so they're more likely to plead. They're more likely to be convicted if they go to trial. They're definitely more likely to receive harsher sentences. That's the denial of justice, as far as I'm concerned, that this situation of this bond has created. So, PJI, Pretrial Justice Institute, did a study of people in Cuyahoga County. This is over the last year. They sampled 4 different jails. And these are the eye-popping statistics. And there's a reason why. 25% of the felony population couldn't make bond. They were stuck in jail throughout their entire stay, and the average stay was 104 days. Now, I don't know what it costs. You get these differing costs of a day in jail. Let's assume it's $100, okay? That seems kind of low. But at $100, that's $10,000. Who do you think's paid for that? Of the 75% of the felony pretrial population, these are people who got out. They were going to get out. It just took them a while to get $200 from this cousin and sell this thing and get $400 or $500. People who got out anyway spent an average of 17 days in detention. If you think 2 or 3 days will ruin your life, and I'm hoping you're thinking along those lines, imagine what 17 days does. And here's the one that just drives me crazy. 38% of people who got a personal bond spent more than a week in jail. And you say, well, how did that happen? How could that happen? And I gave you the example. You get arrested, you have a bond set by the judge, nobody's looking at your case, and by the time the court case comes up, you spent 3 or 4 or 5 days in jail. And then everyone looks at it and says, oh my God, give them a personal bond and let them get out. And that's one of the reasons that we have people there. But of the defendants with $5,000 or less, how important or how bad could that crime have been where their bond is $5,000? They were stuck for all 104 days. There's something wrong with that. So we touched on it. You know, you're supposed to set bail. The idea of bail is for releasing people, not detaining people. And yet, look what we do with our bail. And this is a common practice. I'm not picking on any judge. Almost all of them fall into this trap. They want to send a signal to the community. And I think one gentleman said, you know, it's the cameras are there, right? And, there's 3 cases that stick out in my mind. There was a young man in Mentor. He was driving his car on I-90, and he hit a police officer and killed him. I mean, that's horrible. And I don't know if he was under the influence of drugs at the time. No one does. He left, but I know the young man and his family, and he's living with his family, and his father was like a paramedic or something like that. Anyway, the judge set a bond of $1 million with all the cameras around. There's a young man who struck somebody who was riding one of those bird scooters in Cleveland. He's 19 years old. He's living with his family in Sandusky. A Cleveland judge set $1 million. There was a North Royalton man, 3 homicides. 3 homicides, $25 million per homicide, $75 million. And then the judge kind of laughed and said, and I'll make that a 10% bond. So all he had to do was come up with $7,500,000, and he could have got out. So, you know, there's a political aspect to this, or a desire to show the community that I'm tough on crime. Here's the one, folks, that we're going to ask you to really rethink your positions on this, because this is the one that is going to be the dragging and screaming and kicking. Courts or cities are using their courts as an ATM machine, a big cash cow. And I don't know how many of you have had to pay a ticket, and I'm not going to name any particular courts, but there's one on Van Aken and Lee that probably has the highest court costs. There's also one out in Berea. These court costs are basic court costs are $90 in South Euclid. I think they start at $225 in Shaker. These are court costs, okay? Why? I don't know why they're not the same, but here's what happens when you post that bond, okay? You go to the window, you finally got the money together, you post the bond, and you sign for it, and your case is over, and you go back to the window with your bond receipt, and you're waiting for your, let's say, $450 back because it was a $5,000 bond. You posted $500, you're giving them their 10%, and they say, oh, here, look on the bottom of your bail receipt. You said that we could use any bail deposit to pay fines and court costs in your case. And this is, to me, one of the great sins that every court is committing, and that they're using the bail amount as a deposit, as a guarantee that they're going to get their money. And I think that's shameful, and it's uniform. City of Cleveland is under a different jurisdiction now. They've engaged a whole different bail process. We'll talk about that in a minute if I can. And this last one is what I described to you before, a high bail. The guy will come up in a week. I know the case will be over with. He'll plead to whatever, and I'll sentence him to time served, so the case is gone. So 1 week, that case is over with. And these are some of the bad reasons that the judges are setting bail bonds for. And you know, this is a bunch of people who are following the rules, who think they're doing the right thing, and that's when we have to take a step back. That's what this bail bond reform did. It wants us all to take a step back and look at what we've created. And the inequities, of course, are borne by who? The poor, the unemployed, and this is what we decided we needed to do something about. So that's a break. One of my law students said you should have a break. Okay, now you're done with your break. And the idea behind what we tried to do is make things, first of all, consistent for everybody. The $10,000 bond in one community for the same crime that across the street would be $2,500 is inconsistent justice. That's plain and simple. And so our idea was, how can we centralize the entire bail process? Remember, bail is a process. It doesn't equal money. So the municipal courts should adopt a system of centralized bail hearing for all defendants in the municipal courts and Cuyahoga County. They do it in Hamilton County, Cincinnati, Ohio, and Hamilton County. They do it in Lucas County, Toledo. And the idea is that we don't start with money as a bail bond. We start with information. And we spend money up front so that we don't have to spend it on prison and jail, because jail costs maybe $100 a day, and some of these improvements that we like cost $4 or $5 a day on scale. And those include pre-trial services. There's 2 municipal courts that are experimenting with pre-trial services. Pre-trial services, I think the Adams Board, you're the Adams Board fella, okay. Do you know of whether there's any communities that use you for pre-trial, not post-trial, not after someone's been convicted?
You mentioned the Shaker Heights Court. I must tell you, though, they do have a mental health court that they use effectively and for the free program.
Mm-hmm.
So there is a pre-interview process if there is any reason for addiction or mental health services in a couple other municipal courts, like the South Euclid Court.
Okay.
We also have that. Many municipal courts won't get involved in that. That we can't figure out.
Okay, this is why we're here, because obviously you would think that would be a good thing for those other courts. Well, so do we. And what is the problem? Why should somebody be afforded that in Shaker or South Euclid and not in East Cleveland or not in Parma? Parma's got money. Andy, I got a little money anyway. Parma's a big community. It's got a big court. Many jurisdictions pour into Parma Municipal Court. They're open to the idea in Parma, but how do we get this done where right from the arrest we find out if we could provide services for people other than tossing them in jail? I don't know what your familiarity is with drug addiction or alcohol addiction, but you throw an addict in jail for 3 days, or an alcoholic with serious DTs in jail for 3 days, that's hell. That's absolute hell. Why do that to the sheriff's deputies who have to monitor these people, and certainly to the individual themselves? But that's what we do. And so at least 10 or almost 10 of the municipalities, they let people detox in their jails. That's criminal. We shouldn't be doing that. So pretrial services don't necessarily just deal with drug addiction, mental health issues. Again, there's ways to assist the defendant in getting through his case without ever spending 1 day in jail, but it all starts with finding out just exactly who this person is. You might ask, well, how many people skip out on their bail? And I'm going to tell you, I have no clue, even though I was tasked with finding out. The best I could come up with is and that's by just getting the number of warrants from each community, and this whole effort took 1.5 years, is that there are as few as 1,000 warrants outstanding, or at least when I wrote the report, or my part of the report, and as many as 4,000 warrants. But nobody keeps any data about anything. And what we're advocating for, and I think would make sense to most of us, is arrest them, give them their citation, tell them they have to be in court on a certain date, and see what happens. Maybe that would be the best way to find out if, as I believe, the vast majority of people will show up at court and they'll dispose of their case. I don't know what we're afraid of, but nobody's ever collected the data. And this is the problem that we could solve with a uniform database. The uniform database not only would show somebody's propensity not to return to court, which would be factored in to what the conditions of bail would be, but it would certainly show whether or not somebody has cases in North Royalton and now they're in Euclid. There's no way to tell that now. No, none whatsoever. So when the Euclid judge is setting a bond, what are they supposed to do? And these other communities, Hamilton County, Lucas County, they have invested, Summit County has a great pretrial services program. They've invested hundreds of thousands and have calculated that they've saved millions on just getting some idea of who they're dealing with and how they could possibly help the situation moving forward to resolve the case. We have asked the judges, these are the specific recommendations now, that there should be a presumption of personal recognizance for certain offenses. For the following offenses, the release should be personal, unless the prosecutor, and by the way, where is the prosecutor in all of this? Unless the prosecutor brings to the attention of the court, no, you can't put him out on personal bond, here's why. In that Salerno case, one of the rulings by the Supreme Court was that the prosecutor had to show by clear and convincing evidence that there was no reasonable bail procedure that would keep the community safe or make the defendant appear. The burden was on the prosecutor. In our entire bail system, the burden's on the guy who's charged to ask for a low bail or to show the judge why he should get a low bail. So we're suggesting, and now this report was written March 2018. We've done more research. I'd add about 10 more offenses to this now and have this default presumption that almost every misdemeanor offense, with certain exceptions, domestic violence is certainly one of them, should be personal bonds. But the ones we had at the time were things like driving under suspension and nonviolent offenses, and I lost my place here, but there were 4 of them. Offenses that you can't go to jail for. So for example, if you're charged with a disorderly conduct, which is a non-jailable offense, except when it is a jailable offense. That made no sense. But under the state code, it's a non-jailable offense. It's a minor misdemeanor. It's not even it's not a crime, even. Under most municipalities, it's a higher elevation of an offense, but nobody goes to jail for disorderly conduct. Come on. And so somebody pleads and there's some conditions, and the defendant does not comply with the conditions. And so what they did was issue a warrant for his arrest and jail him. Well, he wasn't going to go to jail in the first place. So it's not like the crime gets you, it's the cover-up. How often have we heard that? And that's just completely inappropriate. Driving under suspension cases, There are some exceptions to that. Offenses that are not any crimes of violence. There should be, so we're handing this to the court. Just change your rules and let personal bond be available. No secured bonds for municipal court offenses. Oh, did the Bail Bond Association go wild when we proposed this one. In fact, they're fighting this at every turn. But that's who's going to suffer for this. And, you know, they can still get involved in felony offenses if they want. A uniform bond schedule. This is that first slide I showed you. Why is driving under suspension, by the way, first-degree misdemeanor. So the bond should be $10,000. You pay $1,000, okay, in Shaker Municipal Court. But why does it have to be so different? Why can't all of these crimes, all the misdemeanors, be consistent throughout the county? All they do is pick a number, okay? Can they agree on a number? And the answer is, of course, they can't agree on anything. That would be the uniform bond schedule. Less costly forms of bail and lower bail amounts. I don't know if any of you have bailed anybody out of jail. I had to bail someone out of jail in Brecksville for an OVI. And this person was a resident of Brecksville. And, you know, the Audi he drove drunk in showed that he had some means, and they arrested him, and I was the sucker who picked up the phone. I mean, that's a call I wish I wouldn't have picked up, but I did. And so I went out to rescue him, and I knew one of the police officers, waved and all that stuff, and I said, I'm here to post bail for this person. And I pulled out my credit card, and he went, I said, oh, okay, fine. So I grabbed my checkbook and went, no, we don't take credit cards, we don't take checks. And it was a good thing that it was between the hours of 8 and 4, so I could go to the charter, it was Charter Bank then, now it's Citizens, and pull $500 in cash out of a bank account so I could take it over to the police station. Had the bank been closed, I don't know what would have happened. Had the police station not been taking bonds at that time. These are the problems that they're different in every municipality. What they'll take for bail, the reliable source of payment, when they'll take it, who you can post it with, it's different. Why can't we have some consistency? And this is what we're trying to get the judges to agree on. You know, there's two reasons that you give someone, that you make someone have a condition of bail. The first is to show up, okay? And we are just naming crimes and associating them with dollar amounts. So, and if your crime's aggravated something, then you get a real high dollar amount. But there's absolutely no rationale between a bond that we set on a 4th-degree misdemeanor, criminal damaging, and $2,000 or $3,000. It has nothing to do with setting a bond when you're worried about what the person is going to do if you let them out. One, to appear at court, but two, and this is the big one, is to protect the public. That's the reason we post bonds. And so, when we're giving people bonds who cannot afford any bond, we're doing them an injustice. And then when we're posting a $25 million bond on someone because of the nature of the offense, the name of the crime, there's no relationship. Very wealthy people could post those bonds and get out and still be a danger to the community. And so what we are advocating, and this, I know those were exaggerated examples, but this really, the rubber meets the road in domestic violence and stalking and aggravated menacing cases, okay? Where no amount of money is going to decrease the danger between the victim, or just ask the victim, and the person who's accused. And yet, that's what we do. We give them a high bond, as if that's going to have something to do with it. Our recommendation is, if you can't figure out a way to let someone out safely, and money might be a piece of it, money could be a piece of it, then don't let them out. There's this charade that we use. Bond is not meant to detain people. It's meant to release people. And yet we engage in this for many different reasons. This high bond for an individual who has no chance of ever making this bond. And we think that that's doing justice because the 8th Amendment says we have to give them bail. So what we are devoting a lot of our resources to are risk assessment tools. And these risk assessment tools are available. All I have to do is Google the Ohio Risk Assessment Tool, and you'll see what they use in Common Pleas Court. And it considers many, many factors, a lot of which were on the Common Pleas bond schedule, and it rates them, and it rates every person who's accused of a crime, and it tailors some means other than incarceration to make sure the failure to appear is nowhere near as important as the propensity for violence and the danger to the community. And so what we do is we use ankle bracelets, and we use scram bracelets, which will identify any alcohol use whatsoever. And we use day reporting systems. And many of these things cost less than $10 a day. Incarcerating them costs all that money. Domestic violence is really tricky, but there are domestic violence risk assessment tools that we can use too, because somebody might be absolutely no threat to anybody in the public except for one person. And that would be the victim of that domestic violence. And so we have to use specific domestic violence risk assessments in order to create conditions for the release of the individual and still make sure that the victim or the complaining witness is still going to be safe. And Lucas County has released more defendants before trial, more appearing for trial, less crime committed while they're out. And they've gotten the data, and they've shown the propensity that we're fearful of something that we don't have to be fearful of, and we're throwing money at it, unfortunately. Money bail should not be used to address danger of risk to the community. And I'm running out of time here, so I'm going to fly through this. Just deny their release. Okay, there's appellate procedures. When you deny bond, there's a court of appeal, or sorry, a statute that you can go to the Court of Appeals on and get a bond set for an individual. So we have mechanisms. Just deny the bond. This system of centralized bail hearing would increase the ability to improve this process. Again, those are the benefits of it. The court staff could work 7 days a week. All you need is one judge. It's not like you need every judge to be at their desk. If you centralize this, all you need is one judge and one court staff. You could have an east side and a west side bureau if you wanted to. You should be available or able to post a bond 24 hours a day, 7 days a week with some reliable means. We don't have that possibility either. This is why people spend 5 or 6 or 7 days in jail before they get a personal bond. And the ultimate solution to this is something we've dumped in the county administrator's lap. Armin Budish has it. I don't know what he is going to do with it, but the problem is, the real problem is that we have 13 political subdivisions, and nobody wants to give up any of their turf at all. They want to do things the way they've done it, and this is going to take money out of the communities that those courts serve, and that's where all the resistance is. So I don't know how we are going to tame this, but I kind of, that's Judge Russo on the left and Budish on the right, and those are all the municipal court judges, and they're working on it. But what we do need is we need a change, a cultural change here, and we need to stop thinking that money equals safety to the community, and that we have to start realizing that the imposition of money bond provides a great and gross disservice to people who are unlike us, but who happen to make up the majority of the population of people in the criminal justice system. I'm almost done. I guess I am done. I don't know if there's a question or a comment. Are we good? You can't stay after school.
We have time for a few questions. So.
Yes.
How often does the domestic victim go to jail for their significant other or something?
Yeah, if you want to talk anecdotally, I can tell you this. Judge Michelle Early at Case Trail was kind enough to allow our students to practice in court. And so over the years, we've developed a great relationship. She is now she's the chief judge, but she was the dedicated domestic violence judge. And the bonds were significant. And by the time the case got processed, for reasons kind of
like what you just said, where the crisis was over, and the next day dawned, and now the victim wants to post about it. The defendant, the fight is over. And look, I'm not judging these folks. The realization he's in jail, and I got these kids have to go to school, and normally if he wasn't in jail, he'd be here. Who's going to pay the rent? Because I need his job to pay the rent. 70% of the cases we handle at the Kramer Law Clinic Center were either dismissed or pled down to a disorderly conduct from our domestic violence. Now, I'm not saying it's like that across the board, but it was very, very frustrating for our students. They have to try to represent people when the strategy was just wait. Just wait. Watch what time does. It happens. It's terrible. Yes.
Sir, if I may mention, about 45 years ago, on a much smaller scale, there was a county problem similar to this, but on a much smaller scale, and that was the ticket citations of all the municipalities due to the fact that nobody wanted a municipal ticket to be the same as the next. What they did was because they took care of tickets in certain jurisdictions, right? So what happened was, how do you get all the jurisdictions to have a uniform citation? Do you recall this at all?
My dad was a police officer, and I remember him telling me about people
What
that
happened was taken care of in Columbus. Columbus put it out in a law that said you have to have uniform citations, and that did it. And has there been any activity in taking this to the legislature?
Yes, home rule stops it. And the better guy to discuss it, you know more about home rule than I do, but that's what the problem is. Home rule prevents a municipality from being forced to adopt the state code.
And on top of that, I would argue in today's political climate, I'm not going to rely on Columbus to do much of anything. Do you mind if I put you on the spot?
Go ahead.
So, as an elected official in one of these municipalities,
That's not me, that's you.
yeah, that's me, and the head of a legal committee, and I'm really, for those of you who don't know, I'm really putting Carmen on the spot because his daughter is our prosecutor and assistant law director of the city. Is what changes can local officials have, to put pressure on their own municipal courts? Is there any, or is that really up to the independent judges?
Everything has to go through the legislature. So, for example, there's no chance you're going to have 5 municipal courts districts.
No.
It's just not going to happen. It has to go through the state legislature to make those types of changes. I will tell you this, I did not put a quote from Justice Maureen O'Connor, but she's made it kind of her mission. She's leaving us very soon, and she has made it her mission. This is a letter she sent out to all the judges. This doesn't just apply to bonds. This applies to fines and court costs also. And it creates a barrier to access to justice for everybody. But mark my words, there's 3 states that don't have bail, money bail. Alaska, Delaware, and California starts January 1st. I haven't talked to her because she and I don't talk. But I know it's her mission to eliminate money bail in Ohio. She moves to the Supreme Court, which I believe is at the end of next year. So, yeah.
One more
Professor?
I remember reading about a scandal about bail bond system. The theory was that if you post a surety bond and you don't show up, bondsmen will go look for you because you have the financial interest, right?
That's a theory.
And if he doesn't get you to show up, at some point, the bond will be forfeited and paid into the court, right?
Wrong. Yeah, it's supposed to be, yes, in theory.
I wrote an article years ago about how that never happened. Bonds are never forfeited.
I've been doing this 40 years. I've never heard of a bond. 40 years, I've never heard of a bond being forfeited. The bail bondsmen go and see the judge. They beg for continuances. The judges usually give them. I've never heard of a bail bond, like a $50,000 bond. It's an insurance policy. I've never heard of one being forfeited because...
Insurance company never pays the claim.
No, they don't have to. They're correct.
I know we have one more question from a young lady in the back of the room. Oh, it's not hand up, right? No? All right. Thank you, everybody,
Yeah.
for your time. Thank
Thanks.
you, Professor Carmen.
Well, thank everybody.
Great.
Hope it was okay.
Fantastic.
Hi.